I believe if you have a 7 or 8 figure case, you have to do in-person depositions because there is something about being in person that adds pressure to that witness. That there's something about physical presence that makes them want to give you the answer. They will fold at some point to give you the answer that you need. The best answers I get in-person depo are after 4 hours. If I've got you on an in-person depo as the defendant, you are probably getting a 5 to 6 hour depo.
So how do you identify the tower? Because a lot of times I found we will have initial disclosures, written discovery, even depositions, and later we'll learn that there's an excess policy that wasn't otherwise earlier produced. So it's not that we haven't asked the question, but they haven't produced it. And have you experienced that? And what are some tips and tricks to identify the full scope of all the coverages?
So all you have to do is rely on the honesty and integrity of the insurance company.
Right.
No, that is not what you do. So if you think about, the short answer to this is the way I figured out, I just did this last week on a depo in San Antonio, where I took a deposition of a corporate representative for the company. And I just knew this oil field services company, they had to have more than $1 million. If you knew anything about the work they did, they just had to. There's no way their customers let them roll out there with only $1 million. And nobody had ever given it to me. So I do a corporate rep depo on that topic, among other topics.
So wait, let me back you up a second.
Yeah.
So you've already sent them written discovery.
Sent written discovery. Sent emails. Hey, there's got to be an excess policy. The lawyer says, my client says there's not. The carrier says there's not. But there's got to be. So months of this.
And then to get the corporate rep depo, you have to send topics.
So yeah, you can't just say, boy, I'd really like somebody from your company to come testify. You have to send a list of discrete topics that corporate rep then has to prepare for. And under Texas law, that corporate rep has to actually prepare for that topic. And so when you ask for excess insurance policy information, that whole tower, the first question I ask in any corporate rep depo is I get the list of topics and I say, okay, topic 1, have you prepared for this topic? What did you do to prepare for this topic? What documents did you look at to prepare for this topic? Okay. Now, in this depo I just took, I had 35 topics. He had prepared on 6 of those topics. Okay. 6. And so I had him circle on the notice all the topics he didn't prepare for. And write NP for not prepared next to each one of those topics.
Excellent.
But he had prepared for the insurance because I had talked to his lawyer so much about the insurance.
And this is an in-person depo.
Oh, yeah. Listen, if you have, I believe, if you have a 7 or 8 figure case, you have to do in-person depositions because there is something about being in person that adds pressure to that witness, to where they can't hide behind the screen, they can't see email pop up, they can't just do whatever. That there's something about physical presence that makes them want to give you the answer. They will fold at some point to give you the answer that you need. You know, the best answers I get in an in-person depo are after 4 hours. If I've got you on an in-person depo as the defendant, you are probably getting the full 6. I mean, it's going to be a 5 to 6 hour depo. A friend of mine and I took a depo, a defense expert, 2 months ago in Houston. And the defense lawyer let us go 11 hours. Like we were physically there 11 hours.
Okay, so you are far from the lazy lawyer because most lawyers are, here's the Zoom link, let's get through this depo, and they are running through it. You're actually flying to these cities.
Yeah.
And putting yourself up at your own dime to take this in-person depo that is at least 4 hours, maybe 11.
So
it's amazing.
So printer in tow. So I bring a printer with me.
I was going to hit on that because I want you to tell the audience what you do with the printer because that is so clever.
So we'll do the rep topic first. So on the excess policy, he then comes. And like on this case, it's okay. I know I have this excess policy from Scottsdale. Okay. Do you have any? No, I don't have any documents on it. Okay. Thanks, buddy. So then I send a letter of rep to Scottsdale Insurance Company and say, hey, I'm here. Here's this insured that you apparently have. Okay. and they say that you're insured. Okay, it turns out they do have an excess policy. Now, if you think about, you could chalk this up to nefariousness.
I was going to say, can't they get sanctioned for hiding the ball? This just doesn't even seem fair.
So it's not fair. The lawyer on the other side is not doing it on purpose. That's not who she is. She's not trying to hide it. What's happening is the case comes in from the carrier. The client doesn't. If you're the insurance defense lawyer, the client's not calling you. The carrier's calling you. The carrier only knows about their policy.
Right.
Then you talk to who's the client contact? Local manager of the yard where the wreck happened. He doesn't know. You've got to get to the right client contact before you find the person who even bought the insurance policy. And even then, that person may or may not remember if you're 2 years removed from that policy period. Mm-hmm. So what you do is you have to have the corporate rep topic because they have to then study it and talk to the right person, or I'm just going to embarrass them, and then file a motion for sanctions on that issue. Then you find out who the insurance broker is, and you can send a DWQ to them. And I've done that on multiple cases.
I love that. The DWQ to the insurance broker.
Yeah, and they'll tell you. That insurance agent ain't going to lie. I mean, they're going to tell you. Now, the pressure point for the insured is a lot of times they are worried about their insurance rates going up, and so they don't want to tell you. And then they have to be convinced that, buddy, the case ain't settling for $1 million. You're going to be stroking me a check for a bunch of money, or, your excess policy that has very low premiums anyway, relative to the primary, you just got to show me what that is. You're already being rated for risk. You're in the oil field. It's high anyway. Okay, we're going to get it. That's how you do it. You got to get the corporate rep topic and then be willing to send DWQ to the insurance broker. Now, okay, once you have that, then it's building the damage model up to meet those layers and putting pressure on those layers. Now, what was the next thing? What was the same?
I wanted you to share what you do with the printer in your depositions. So you do depositions in person, and you actually bring a physical printer with you to those depositions.
The portable Epson printer.
Okay.
With a ream of paper.
We'll tag the portable Epson printer for everyone.
That's right. We'll have to find a link for the show notes. But so this is key. And a lot of times at this point, I'll bring an associate lawyer with me to man the printer or whatever. But people say, if you talk for 4 hours in a dep, you're going to say dumb stuff. One might say it's candid. You're finally admitting to the dumb stuff your company does. It creates risk for people on Texas roads and highways. Usually it's bad safety policies or bad driver rating. Or your driver's been over hours so many times, you keep letting him drive. Okay. And then people in moments of candor will say something. That then, in Texas, after the deposition, the court reporter puts in a little booklet or sends an email with it electronically, and the witness can make changes.
Right. To that deposition.
I didn't understand the question. I was flustered. I misspoke. Now, I get one of those statements. Like in this last deposition I took last week, the only safety training we do is upon hiring. That was something that a supervisor said. There is no driver safety training after date of hire. Okay. Now, is that true? Yeah, I think it's probably true. But some enterprising defense lawyer would say, well, y'all encourage people to be safe. Your safety guy will send something out every now and then. You may have a toolbox meeting at a job site where somebody says, do safe driving. You may talk to a friend. They may massage that answer on the back end. Okay? Because on the depo changes, you're not getting the witness's answers. You're getting the lawyer's answers. So what do? You get the printer out.
During the deposition.
Oh, yeah.
Live.
Got the printer. It's like, hey, hold on just a second. Let me work on this. Just, because if you play the clip, you can edit out the pause.
Right.
Okay. So what I do is have date at the top, witness name at the bottom in italics, and their title. Supervisor for XYZ oil company, safety, whatever, HSE manager. And make bullet points. At XYZ Co., our only driver safety meeting is date of hire. Signed, XOXO, whatever. And print it off, show it to them. Now, I think this is I think you just told me that your company does no safety training after date of hire. You understand? You said that, right? Yeah, I said that. And lawyer hasn't had the opportunity yet because we're eye to eye.
Right.
That lawyer is sitting over there. He can't see the look on his lawyer's face.
Right.
So then I print it off, show it to him. This is what you just said. Mm-hmm. Yep, it's what I just said. Do you agree with what this document says that XYZ Co. only does driver safety training on date of hire by video? Yes. And there is no other safety training y'all do. Yeah, that's correct. So I'm going to mark this Exhibit 3 to your deposition. You agree with the statement that's in Exhibit 3? Yes, I do. Now, done. Now, what do I have? Well, that exhibit serves 3 purposes. 1, I attach it to a Stowers demand. Okay? And it's clear, like your guy, it just visually looks great.
Right.
And you can drag it as a PDF. And
right.
2, it is an exhibit in other depots.
Excellent.
So now I've got a notebook because I'm old school and I'll have a physical notebook with me.
Right.
Okay. And I just pull out a copy of it. Hey, your guy said this.
Right.
I'm not pulling out the transcript. I'm not having to do a word search. I mean, I can do that.
Right.
I've got it there electronically if I need it.
Right.
But I show it to him. And now this next witness has permission to be honest with me. Because he sees his boss has said this.
Right.
Okay? His boss has agreed to this.
Right.
I agree. If my boss said it, it's true.
Right.
So I have I'm not going to get in trouble for agreeing with my boss.
Right.
Okay. So I should. Yeah, you agree with that? Yes. And then I'll type it up for him. Okay? Now we have you agree with this.
What do you mean type it up for him?
I'll do it with his signature on the bottom.
Okay.
Now, some defense lawyers will let you get away with this. I have had witnesses physically sign these pieces of paper, which you can't make them do.
Right.
Okay, it's an oral deposition. You can't make them sign something. But you get the right defense lawyer.
What's the purpose of them signing?
Because you show a signed piece of paper to a jury, it adds to the gravitas of the statement.
Wow.
It just adds weight to it. Okay, but as it is. But typically what I'll do is I'll just type it in, italicize it, bold it, whatever, make it look like an electronic signature.
Okay.
Show it to them, they agree to it. Now, the next witness agrees with that. I'll do the same thing. I agree with my supervisor, so-and-so, that all the safety training we get is blah, blah, blah. Show it to them. Is that what you just, yes. Exhibit 4. And I do continuous exhibits throughout my deposition. So if I do 20 exhibits in Depot 1, I start at Exhibit 21 in Depot 2. So that I can continue with my notebook as we go throughout the life of the case. Okay. And then, so the first purpose is I can attach to a demand letter. The second purpose is that I can show it to other witnesses and kind of give them permission to agree to it or impeach them with it.
Right.
The third is the question I've asked in the deposition is, do you agree with that statement? Okay? That's the question I've asked in the deposition. At trial, I will say, isn't it true that, whatever that's, you only have safety training first day of hire? And they say, yes, I've got them. Okay, yeah, that's what we do. We do bad stuff. Okay, great. But if they say, no, now the lawyer's gotten a hold of them. We do all this other safety training.
Yeah, we can cure the record. Yes,
now, wait a second. I showed you a very simple statement. And you remember, you actually watched me type it up so that I can make sure I understand what it was you were saying. In other words, it doesn't just show as a clip at a depot.
Right.
You can show that clip.
Well, also shows that you're not tricking him. You're basically saying, this is coming from you. I'm not here to trick you. I gave you every opportunity to get the record straight.
Exactly.
I typed it. I showed it to you. You agreed with it. That's showing you gave him all the chances.
I hand him my pen and say, cross out anything that's not true.
Right.
And if it's not, I'll keep typing until we come to an agreement on what this piece of paper says.
Right.
Okay. And so they have ownership over it. Oh, you wouldn't word it? How would you word it? Like, how would you word your bad safety training? And then you get it to the point that he agrees with it. He adopts it. Okay. And I'm telling you, by hour 5 in a depot, it gets real easy.
So do you just do that over and over throughout the whole, how many exhibits would you have?
So the last depot I took, again, last week, I did in one depot 48 exhibits. And of that 48, man, I would say 25 were stuff I generated on the printer.
Wow.
Okay. Now, listen, I'm not the fastest typist anymore, but I'm pretty good at it. So get it typed up, and you have to be comfortable with silence. So something a lot of lawyers are not comfortable with is silence. And so, hey, you got them there 6 hours. You're paying for the time. I'm paying for the videographer. I'm paying for the court reporter. I've got you there 6 hours. I can take 20 seconds and type something up, let it print on a little portable printer, show it to counsel.
And you put the sticker.
And what I do is I put the sticker on it after they agree to it. So that I know on the back end, okay, if it's got a sticker on it, somebody agreed to it. I don't have to like double check in the moment. That they
so have you seen where the defense attorney, when he catches onto the pattern, he wants to maybe take a break and figure out, like, I've never seen this before. Yeah. What do I do?
It's great.
I would imagine like even seasoned defense attorneys would be like deer to headlights. Like, what is this?
So there are a few lawyers who do it. And so it's not entirely unheard of. I mean, I got it from somebody. But what they do is they struggle with, you're creating this exhibit and getting somebody to agree to it. They're struggling with they know that it's not good for them. Okay.
Right.
What's the objection?
Right.
What's the objection? In a deposition, the only thing the defense lawyer can object to with regard to their witness is form. I don't like the way you've worded the question. And privilege. That's it.
Right.
And it's not privileged. And do you agree with what this piece of paper says is a very simple, uncomplicated question to which no form objection could ever survive.
Right.
Now, it doesn't make that document admissible at trial. It's really there as an impeachment document. If they change their test. Yeah. You have created the cudgel that you're going to beat them over the head with if they change their testimony at trial. I said, I object to the process. Every time, I object to this process. Okay? And you just keep going.
You just keep going.
Sometimes if you're salty, you'll say, hey, that's not an objection. If you want to embarrass them a little bit.
Right.
But, last week, the lawyer said something like, I object to the form of this. I object to the admissibility of it. They're just making objections that don't apply to what it is you're doing.
Right.
Because it befuddles them. And so now we need to play our game. We don't need to play their game. Okay? What am I doing? I am building something for two reasons. I'm building it for trial if we got to try the case. But 99% of the cases don't go to trial. I'm building ammo that defense lawyer can use to get me paid because she don't want to go try this case because her witnesses are agreeing to all kinds of dumb stuff on the record.
Right.
And so I am arming her because your defense counsel can be your best friend.
Right. You're actually papering her file for her to go get the authority to offer the money you're asking for.
That's right. That defense lawyer is supposed to
making her job easier.
100%. Once they realize that, it's great.
Right.
So what they have to summarize these depots for the carrier. And I guess probably they'll run it through Claude or whatever at this point anyway, or some software that Allstate has or Nationwide or whatever. But hey, I've created these exhibits for you. Send your adjuster these exhibits and tell her that the witness agreed to all this dumb stuff. And then they get nervous. And I have found that if you've got a 7 or 8 figure case, every depot will add value to your case. Find the name of every person you can identify in that file, and you keep going until they pay you.
So do you redirect on your own clients' depositions or no?
No, never. The only thing I will do is if I have an unusual damages case where you have like a significant mental anguish component, like this kind of above and beyond, they may pass the witness, go off the record, and I've prepped the client on this.
Right.
Okay, like they have to have an answer.
Right.
I have to know what's happening.
Right.
I might want to say, hey, something you didn't ask. I think you ought to ask her about this because your adjuster's not going to appreciate the full value of the case if you don't.
So you offer it to them to ask. Okay.
Yeah, why don't you ask her this?
Yeah.
Because I could do it as a leading question, or I don't want to do it. You ask it. And then if I don't like it, I'll say non-responsive or objection form, or I'll clean it up later. I don't want it to be responsive to my question in case it doesn't work exactly right.
Okay.
But I'll have the client prepped on it. We'll have an off-the-record discussion about what it is she's going to say. Okay? Like, hey, you didn't ask her about, like, losing her child after something.
Right.
Okay? You didn't ask her about, going through this deal or, lost this job or whatever. You might want to explore that.
Have you ever considered asking your client about their own reasonableness of the medical bills and saying, how, expensive healthcare is, it is expensive, yes.
Yeah.
Do you get into that or you kind of steer away from that?
So here's what I do. And I think that is a good idea to help arm the defense lawyer, especially. Because obviously your client's testimony about reasonableness doesn't come in.
Right.
Okay. What I do is I make sure that my client has seen her medical bills. Okay. Now, under LOP work, when the client is treating under the guarantee from the lawyer that the bill gets paid and that bill comes to our office, I make sure the client sees that bill. A good defense lawyer will ask, do you know how much your medical bills are?
Exactly. Okay. And if they say no, they weren't prepped.
My client is going to know approximately.
Right.
Not down to the penny.
Right.
Because who knows down to the penny? You can't make it rote. My medical, I know they're about $200,000. Okay. If they were asked a question about mental anguish, one of the answers they're going to give is whether this is real mental anguish or not under the law. One of the answers is, it weighs on me that I've got $250,000 of medical bills out there that I can't afford to pay. Okay. Well, now her testimony about her medical bills is all of a sudden relevant, not for the amount of the bill,
but for mental anguish. That's brilliant.
The effect it has on their life.
Just strategy on counter affidavits and reasonableness.
Yeah.
Do you take their expert depo, or do you put up your own doctor to talk about the reasonableness of all the bills and records? Like maybe a surgeon, that said they reviewed all the rest of the bills, or do you hire your own expert to talk about reasonableness?
Depends on the case, depends on the value. Like a $30,000 car wreck case does not justify, you can't pay.
Well, a case that's worthy of litigation buildup.
Yeah, okay. On that case, either my surgeon is going to be able to testify about reasonableness or my life care planner. Listen, if I have a 7-figure case, I've got a life care planner.
Right.
I've got somebody mapping it out. And they're going to be an expert who can testify not only about future charges, but as to the reasonableness of the past medical.
Right.
Of the charges for the past medical. When it comes to like the prep, hey, I think max verdicts come with the doctor at trial. I really do. I think,
live.
I tried a case years ago in West Texas, and I wasn't the doctor couldn't come to, way out West Texas because of an East Texas client. And I couldn't get the doctor to Monahans for the case. And so we took his depo. For that, video depo, in and out, under an hour. Okay, you got to be in and out, prove it up, show it to the jury. But if you are around where that doctor practices, you want that doctor live at trial. And I think life care planner too. And I'm not even going to mess with the depo of your billing expert.
That's what I was going to ask.
Yeah.
You don't take their
No.
You just wait for trial to if they even show up.
Right. We have done that. I have taken a billing expert depo, but at this point, I'm daring you to bring them.
Right.
Because, your counter affidavit makes me have to prove up my billing in a certain way. I was already going to do that.
Right.
On a case that justifies the buildup, as you say, I'm going to have my doc there, and he's going to say it's reasonable. Okay? I've got it. Your counter affidavit is meaningless to me because it doesn't affect the way I'm going to try my case. Okay? And if you want to embarrass yourself with some pencil pusher who's going to come explain to my surgeon why his bill is too high when he's got to wait to get paid when your client's being unreasonable. Okay, good, do that.
So do you address LOPs and voir dire or no?
Depends on what the judge is going to let in with regard to the LOP. So before you get to voir dire, it's kind of predetermined. It's a fait accompli what's going to come in with regard to LOP. If the LOP itself is coming in, you shine a light on it. And shoot, half the time my clients don't have health insurance.
Right.
And when you do, what I do is I get everybody on my side with the bureaucracy of health insurance. Who has ever been frustrated with having to wait for health insurance approval for a procedure to see a specialist? You see a specialist to get an appointment with a specialist. Like we had to get, my son has an ear infection. We were going to try to get him into an ENT. We're in June right now as we record this.
Right.
It was like August something.
Oh, right.
Okay, well, the infection hopefully is cleared by August.
I had the same issue with a pediatric endocrinologist. It was like 6 months before we even got to the appointment.
Yeah, it's crazy.
Right.
And so that's a common experience everybody has. And then you can say, would you hold it against my client if they could get around the bureaucracy of healthcare? Yeah. And people will not begrudge that. People will not begrudge that because everybody would like to get into a doctor. Okay. And also now when you do this, make sure your doctors are credible. Okay. don't have some crummy doctor who can't testify and who's been disciplined by the medical board a bunch of times.
Yeah.
You have to have a doctor you would go to.
Right.
And so some of my doctors that we use for our clients, my family members have gone to.
Right. Oh, and me as well.
Yeah.
I mean, I'm so selective when it comes to medical treatment. I want them to have better care than they would have through health insurance.
Right.
If possible. And their CVs have to be impeccable and, great results and top of their game.
Yeah, absolutely.
So you did touch on different judges and what they're willing to let you do. And you try cases all over the state of Texas.
Yep.
Is that correct?
Correct.
What is your experience as far as different judges allowing you to cook, so to speak, in the courtroom, and others that are limiting your time and making it difficult?
So you cannot cook in federal court. It is a no chefs allowed policy in federal court. It is, man. I mean, I hate trying cases in federal court because you can't put on the show. Some judges will let you peacock around a little bit. Okay. In other words, some judges will want you to question witnesses from counsel table. Some judges will want you to stand. You will always be allowed to approach a witness with a document. But then you have to figure out, who is this judge? Was this judge going to let me kind of linger here by the jury with the witness and point out how silly this defendant looks, or walk through this picture, kind of hovering over the witness to add a little pressure to him, and kind of walk through the more you can walk through the well of the courtroom,
just physically.
Oh man. Because this jury, who are our jurors? Our jurors are 12 people who are addicted to their phones.
Right.
Okay? Who are having withdrawal symptoms because, like, the jury room, the courtroom, and the operating room are the last places in the world where you're not allowed to take your phone. And so they're getting the shakes over there because they can't check YouTube, Facebook, social media, blah, blah, blah. Okay. And so, you got to entertain them a little bit.
Right.
And it's tough to entertain just sitting there and the other person sitting there. And you're like, okay, you were hurting. Okay, what are your policies? Okay, when did you hire him?
Well, just recently, I saw a trial in Hopkins County, and defense counsel called their biomechanic expert. It was so dry and so technical, some of the jurors were sleeping.
Right.
And I had a hard time following, and I do this for a living. I couldn't imagine what they were actually retaining from just so much technical speech.
Correct. Nothing. That is why if you have an expert, I mean, keep it short with your experts. Because, I mean, engineers are not the most pizzazzy people in the world. Okay? And that's okay. You don't want the guy building bridges to be Mr. Personality. You just want him to do the math. Right? And so you have an expert there to testify live at trial. Man, you need him to just be in and out because he's going to be dry. But that defense lawyer gets an expert, and they've got the dry expert. The jury's not paying attention to him. But then when I get up, when a quality plaintiff lawyer gets up and starts crossing him and exposing where he's wrong,
right,
or where his limitations are. Okay, now the way it works is, they're engaged with the bad stuff and they slept through the good stuff.
Right, excellent.
Yeah.
So how would you recommend to lawyers who are going into a courtroom for the first time, how do you find out about the judge as far as, typically what they'd allow in pretrial, how long the voir dire might be? Obviously, you can ask the judge, but is there any way to kind of get some intel before you even approach, the courtroom?
I would say two ways. One, colleagues is the easiest way. Guys, friends of yours who've tried cases in that court before. And I wouldn't limit myself to personal injury. Who tries the most cases is criminal. Call a criminal law attorney in that county if you find them.
Well, many judges here in East Texas are both civil and criminal. In Dallas, a little bit more.
That's true. In Dallas, in the big city, Dallas, Fort Worth, Harris County, you're going to have, that's right.
Maybe Colin's both.
No, I think you have, I don't know. I'd think about that. I know I had car wreck cases up there, but if you have civil only, you got to talk to those people. But man, in East Texas, family, criminal, everything. Hey, talk to those people. They're in the courtroom all the time. They're going to tell you. All right. Now, the other thing is I had a case, serious car wreck case in Wichita Falls once. I had never even been to Wichita Falls. I never tried a case in Wichita Falls. One day And it was one of my early 7-figure cases. Okay. I was like, I didn't know anybody there. I drove to Wichita Falls one day and I went to that courthouse and I asked to see the court coordinator and I just chatted her up. And I said, hey, she was like, who is this? I'm sure she was like, who is this Yahoo lawyer from, Tyler? But I was like, hey, what's the biggest verdict you've had in this court? She told me. I know you can't recommend a lawyer, but who is the guy people hire as local counsel here when they need to pick a jury?
She would be the perfect source.
And she told me.
Wow.
And I called that guy.
So resourceful.
Yeah. I was like, hey, and he was in town. I popped over. It's like, had a cup of coffee with him. I was like, hey, I'm not going to hire you yet, but if it goes, I want to use you. I'll give you 10 points. You agree. And great. Okay. Fortunately, I was able to settle that case without having to go to trial. But, just local color.
Right. Absolutely.
Nothing beats it.
Nothing.
Yeah.
Absolutely.
Yeah.
And then engaging the jury. A lot of attorneys will use inflection in the voice and, obviously have charisma. Others, like even Mark Lanier, who, is your alma mater at Texas Tech.
That's right.
He is big on roadmaps and using the IPVO. And I'm surprised he's even allowed to draw some of the drawings he draws, as obviously it's just demonstrative. But I'm surprised that, that's even allowed in some courtrooms, but apparently it is. Do you use much technology? Do you use the IPVO? Are you drawing notes? What do you do to engage the jury?
I try to be as low tech as possible.
Okay.
I try to be as low tech as possible.
Why is that?
People are not impressed by technology at this point.
Okay.
You have access to so much technology on your phone. There's very little I can do in front of you that's going to impress you. Okay. What will get your attention is the written word. And so I actually do like a whiteboard. I've got a little portable whiteboard that I can bring to trial and just write stuff on there. Some point that the defendant makes that's I think is silly or to highlight it, just take a moment with your dry erase marker and just write a word.
So you are doing similar to Mark Lanier and drawing or writing, maybe not drawing like he does.
Right. I don't draw. I can't draw.
But you're at least making notes handwritten.
That's right.
In real time.
That's exactly right. And so I think it's important it engages the jury.
Absolutely.
Okay. Now, do you have some technology? Yeah. You have the documents pulled up on the screen or whatever. You zoom in on it.
You're not doing PowerPoint.
Nope. I've never done a PowerPoint at trial. I won't do it.
What about the visual recounter of the accident or something?
Okay. I will do that.
Okay.
I will
when
do
it
that.
Calls for it, the right
case. If the right case calls for it, I will do a medical illustration. Okay.
Right.
On the right case.
Right.
But as far as like some slick PowerPoint presentation, when was the last time you saw a PowerPoint presentation where you're like, boy, that was a really great PowerPoint presentation. Sure, I'm glad.
The way it faded in and out,
Yeah, boy.
Those backgrounds.
Yeah, like in 1999, that was really good.
How he used that clicker, that was,
That's right. But if I never go to trial without an AV guy, okay? And the AV guy, when I've got my yellow pad, I'm like, okay, I know where my questions outlined or the areas of questioning outlined. I know what depo clips are great. He's going to pull up that depo clip to embarrass the defendant. Okay. He's going to have that at the ready. He'll have documents at the ready. He can highlight them and I will work with him on that. And you're doing the dance with your AV guys, really important at trial on pulling those documents up. But then when it comes to just highlighting that dumb thing the driver says, or the safety guy says, that you want that jury to lock in on. I think if you can say it, you can show it. There's no rule that says I can't write something right here.
Right.
If that guy says we don't have safety meetings, or this guy he never signed into a safety meeting, I'm going to write never signed in.
Well, for all those entrepreneurs out there who are also having to do admin, HR, hiring and firing, any advice, because you've had such almost no turnover. You've had, a consistent team, and that really is a huge component and key to success. And you've definitely built a culture in your firm that is, a team worthy effort. What is your best advice in vetting people and knowing who to hire and that will fit your culture at your firm? Yeah.
So I hire culture first. I hire ability second. Okay. Like, do you have experience on this particular thing? If you're smart, hungry, and you are the right cultural fit, my people can get you to be a paralegal. Okay. Now you have to have some paralegal experience. You have to know the terminology. Okay. But if you haven't done pre-lit intake, but you have the right cultural fit and you're smart and you're willing to learn, we can get you there. Okay. Somebody who knows what they're doing, but is bad culture will bring everybody down.
How do you recognize that?
Man, that is vibe. That is
vibe. It's not a specific question. It's not something you're asking.
No, it is 100% feel. Now, something we do is we will have that person go around and meet, usually when we hire, we will have potential new hire meet everybody. Just shake hands, say hi, sit down for a few minutes over a cup of coffee in the conference room with our different groups, pre-lit, lit, lawyer, whatever. But they get a voice, not a vote. Okay, so they don't get to say...
Okay, say that a little slower.
So the staff gets a voice, but not a vote on who to hire.
Okay.
So I will listen to, I didn't like that person. I don't know if that person would fit here. And generally, I agree. Like, I saw what you saw. Okay? But it also helps give cultural buy-in to the new person.
Excellent. Yeah.
Okay? You have to have buy-in. Because if you don't have buy-in to the new person, they'll get eaten up. So this last hire we made of lead paralegal, a person I didn't hire met everybody, and it wasn't going to be the right fit. Great person, just wasn't going to be the right fit. The person I did hire, I knew she was the one. Okay, you just know, like I had it. Like this person is going to be nails. So I hired her, and then I had her come in and meet everybody. You can come in and meet everybody, but here's the offer.
Right.
And our director of ops had her come in, meet everybody to lay the groundwork for cultural buy-in, which we've got.
So you mentioned HR. Do you have HR or is that you? So
it used to be me. And man, my wife would get on me for hiring people on the spot. So interview, I like you. I had a great track record.
Okay.
And I was just like, oh, you're hired. How much to get you here?
Which is rare because most attorneys are not good at hiring.
I don't know. But, I was like, what are you looking for? Okay, well, that's great. We'll pay that. Let's go. Or negotiate it or whatever. Our HR person, our director of ops who does HR, Tish actually interviewed her. And I was supposed to be at that interview, but I was running late from a depo or hearing or something. And we met at the Barnes & Noble coffee shop in Tyler, the Starbucks there. And I get there, and my wife, who has told me for years, you are not allowed to hire people anymore on the spot.
Wow.
I get there.
She broke the rule.
Shane, this is our new HR. I'm like, okay, all right.
Okay.
How's it? All right, you got that feeling, huh? But she's been great. So I am involved in hiring. I've got to meet the person. I've got to like the person, which I think is a key component because ultimately, as a business owner, it's our money going to that person.
Right.
I have to like you enough to give my hard-earned money to you every 2 weeks. So, but she does, coaching and hiring, and if there's issues that have to be dealt with, or vacation, or illness, or whatever.
Right. She's logging all that.
Yes, she's got it.
Okay, great. Well, I want to thank you for your time. Thank you all. Is there anything else that I haven't asked you that you want to share to the audience?
Listen, if they've hung around, they have got it. Listen, this is my last piece of advice.
Okay.
We can capstone it.
Well, hey, everyone, we will do a part 2, but to continue.
Okay. So here's my capstone advice for people. This is the Shane McGuire Happy Life model.
Love it.
Okay. Number 1, find the right spouse. Okay, you find the wrong spouse, it is toxic. And I will say it's better to be married than not. 2, be industrious. If there's a lack of hustle in this world, and if you are industrious and you have hustle, man, you're the one-eyed man in the land of the blind.
Excellent.
3, have a reputation for integrity. Okay, be an honest person. In this world, people don't trust people anymore. And so if in your community and among your colleagues and among the people you work with, you have a reputation for honesty, people will seek you out for hiring, for referrals, for whatever, have that reputation. And lastly, and this, I don't know how people respond to this, but it's so, I am a Christian and I'm unapologetically so. And I believe it is critically important to be involved in your church and to not just be one of those Sunday morning guys. And that's just, I'll just show up and go Christmas, Easter. That's a key part of our life. It's our community. It is the people we go to church with. That's the people we're closest to. And I think having that community of believers is critically important to having a balanced life.
Right.
Because if you're only hanging out with lawyers,
right,
that's not the real world.
Right.
Okay. We have to be hanging out with people that we share that core value with, of faith. And if you're not doing that, I don't think you're doing life correctly.
Absolutely. I share all of those with you, and I'm so honored to know another attorney who is a faith-based attorney who is unapologetically sharing his commitment to his Christian beliefs and values, because I think, especially in our industry, it is almost counterculture to that. And it's almost something that you don't speak about. And in fact, when I saw Mark Lanier, who was a prior pastor originally, I called my parents immediately and said, see, I told you, you can be a personal injury attorney and be a Christian too.
Yeah. He has his own theological library.
Right. Exactly. I'm kind of kidding, but it's the truth. I mean, and if you share those values and you really are committed to what this is. And in fact, my family, who kind of maybe is the counter to what we see on the seedy side of personal injury. They're a little bit more conservative as far as their approach. And now that they've seen what we are able to do for the clients, and that we don't pick our clients pick us, and we get to serve all God's people. Right. And it truly is, in my opinion, the mission field. This is what we are in. If you do not love people, this is not the business for you, because we are 100% in the people business, and we meet them wherever they are in their life to serve them. And we meet a more diverse group of people than virtually any industry you could name except medical. Yeah, that's true. Right? Yeah. Because injury, there's no bias or prejudice with personal injury. All classes, all races, all ages. And, if you're just going at, if you do something, if you're like an engineer or whatever, who are you hanging out with? You're hanging out with other engineers or whatever. Right. And that's great. That's great. Doctors, other medical professionals. Yeah. Right. But we are exposed to areas that we may not be ever otherwise be exposed to. Right. There's different communities within our local community. Right. Right. And so it's a blessing. And you're right, it is a mission field. But it's a layer of pressure, though, to make sure you walk the walk. Exactly. Right. Well, thank you. I hope you'll come again. And thank you for watching. Please like, share, and subscribe to the McKay Law Podcast.